But if you remain in this courtroom and make any outbursts, I'll have you arrested.
All right, I'm gonna move your land, right? That's right, man.
He's done. I'm tired of this shit. Y'all just railroad.
Donald Hugh Davidson Jr., a convicted criminal from Middleburg, was sentenced to death for his crimes. Judge Don Lester described his actions as particularly heinous, atrocious, and cruel. He also considered Davidson's previous criminal record, including a 2010 felony conviction and a 2005 conviction for serious offenses.
A joyful spirit. She never had a bad day.
Wearing a striped jail jumpsuit, Davidson, 38, showed no emotion as Judge Lester read the sentence. Davidson had waived his right to a jury trial and pleaded guilty to multiple charges, including first-degree attempted physical battery, lustful misconduct, kidnapping, and grand theft, according to the state attorney's office. This case deeply shocked Clay County due to the kidnapping of a girl and the harm done to her mother.
And her husband missed her dearly. And there's a huge hole in our family that, was taken away.
State Attorney Melissa Nelson said today marks the end of one chapter of the ongoing nightmare for Rosie Welsh's children, husband, and family.
She's just a special part of us that we'll never get back. We'll see her in heaven one day.
Davidson's lead attorney, Mark, stated, "It is a sad day for everyone."
No one won here. It's a sad day for everyone.
No one won here, he told the news. Mr. Davidson has never wavered in his position of taking responsibility and being held accountable. And quite frankly, he is not surprised that this day happened the way it did. The Karen in this court shows no gratitude for what she has.
It's only been 10 months. Tell me about how you got together and what it is you like about one another.
Well, I thought it would be a good idea. He has strong family values. I come from a broken home. He's strong with Judaism. I've sort of let my faith, dribble away. And but it was a wrong decision. I'm 11 years older. I already have my life planned. I know how I do things. He tries to come in and orchestrate everything differently. Chauvinistic, macho.
I'm just trying to help.
Hey.
Her reasoning in court is utterly ridiculous.
Examples of things that he misunderstands or doesn't.
Yes, ma'am, Your Honor. He texts me, "I'm going to send this person a massage." Really? It's message. Then he texts me.
Yeah, but it's funny. What's wrong with that? It's funny. It's funny.
No, it's not. No, it's insulting.
Give me some other ones, Miss Fisher.
If he was in a professional business situation, like for his job, and he wrote that to one of his clients, they would think he was like some kind of pedophile or something.
Do what everybody else does. That autocorrect. You know what I mean? Autocorrect. Tell me something else.
Well, he texted me that he wants to leak me.
Leak?
So?
L-E-A-K instead of L-I-C-K.
Oh, okay. I got it.
Yeah, but you understood it, right? You understood what I meant.
Not really. No. I really didn't. And besides, why would I want someone to leak me?
Don't even say it again. No, it sounds too, okay.
How about Out of the Woods, Your Honor?
What about Out of the Woods?
We were working on a project, and I said to him, "Oh, cool, we're out of the woods." And he goes, "You need another 2x4?
I wasn't familiar with the phrase.
It's an idiom. It's idiomatic. It doesn't translate literally. Are you gonna get mad about that?
Yeah, I mean, but that's just the tip of the iceberg. That's like the start of it.
Well, show me the whole iceberg.
Underneath it, there's communication issues. Like, for instance, I said, "Go and take that parking spot. It's available, and in Los Angeles, parking is very hard." He goes to the parking spot, stops, waits. Then drives off. The
thing is that you're making.
Miss Fisher, hang on. Mr. Myron, can I ask you a question?
Yeah, sure.
What did you see in her?
What's that?
I said, what did you see in her? I mean, what was the? I'm just asking. So far, I don't get it.
Now, look.
Even the judge is annoyed with her beliefs. On May 1st, 1976, in San Diego, California, Titus Colbert stood before the court to face charges of attempted murder of peace officers and possession of a firearm by a convicted felon. The charges came from a terrifying incident that began as a normal day in Bankers Hill. Colbert's ex-girlfriend called the police, fearing for her safety, which led to a lengthy standoff when officers arrived. Instead of cooperating, Colbert fired shots from his guns, including 2 rifles and a revolver. The standoff lasted 5 hours, causing chaos in the neighborhood, disrupting daily life, and even stopping flights at Lindbergh Field. During his court appearance, Colbert repeatedly interrupted the proceedings.
May 1st, 1776. May 1st, 1776. I stand for a new world order.
At some point during the court proceedings, Colbert could be seen gesturing gang signs with his hands. He was sentenced to 20 years in prison for assault with a firearm on a peace officer. A Tampa man, Lewis Matthews, 43, was sentenced to life in prison for molesting and physically beating a girl, and then attempting to destroy evidence. He was found guilty of 4 separate felonies after a 3-day trial. Judge Kimberly Fernandez imposed a life sentence for physical battery, plus an additional 5 years in prison for tampering with physical evidence, and 25 years each for 2 felony charges of lewdness or lascivious misconduct of a victim. It's heartbreaking to sit in court and watch a victim who has been physically abused by someone who is supposed to be caring for her testify on the stand, said Hillsborough County State Attorney Andrew Warren in a statement. That's why I'm so proud of the work that our prosecutors do to hold these offenders accountable, stand up for the victims, and send these predators away for life. Investigators found evidence linking Matthews to the crime, including DNA on the girl's clothing. A jury convicted Matthews on 4 felony charges. During the sentencing hearing, there were few statements made, and no friends or family appeared to speak on behalf of either Matthews or the victim.
I'll stipulate that he was on probation at the time that this alleged offense occurred.
Is there anything that you wish to say?
No, ma'am. I thank you for your time.
Keeson Wilkins pretended to have a heart attack while in court. In 2004, Ohio resident Keeson Wilkins encountered legal issues after firing gunshots in his neighborhood, leading to his arrest. Facing serious charges including multiple assaults and weapons violations backed by strong evidence, Wilkins decided to represent himself in court despite warnings against it. However, as the trial progressed, Wilkins realized he had taken on more than he could handle. During a court hearing in Montgomery County, Ohio, Wilkins was responsible for cross-examining a police officer. It was at this moment that Wilkins slumped to the ground, pretending to have a medical emergency. Police officers rushed to aid Keeson, but the judge, familiar with Keeson's past behavior, remained unmoved by his theatrics.
It should reflect that the defendant is slouching over to the side and acts like he's sleeping. His breath appears to be quite normal. Doesn't appear to be labored in.
The judge ordered a restart of the hearing, but Keeson continued his act by slouching in his chair for the rest of the proceedings. Despite his attempt to deceive, Wilkins was found guilty and sentenced to 42 years in prison. In a throwback moment, a spectator raised his middle finger and was then held in contempt of court. The judge then addressed him sternly.
You recognize the individual contained therein on that photograph, sir?
Yes, I do.
Okay, and who is it?
This is me.
Okay. And what is that symbol that you are projecting with your fingers?
Using my middle finger, and I am sorry.
Okay, and what does that mean, sir? When you extend one's middle finger?
The next convict, named Karen, was sentenced to 20 years in prison for charges related to drunk driving and murder.
It's 20 years, and by law, I can't run them consecutive. I must run them concurrent. The court thus sentenced you in honor of the life of Lisa DeDucey to a term of 20 years in the custody of the Mississippi Department of in honor of the life of Mark Pope. The court sentences you to 20 years in the custody of the Mississippi Department of Correction. Because this court does believe that Stuart Irby had a hand in that wheel that night, the court reduces the sentences of 20 years by 2 years and run each of those concurrently. You will thus spend 18 years in the custody of Mississippi Department of Correction for the life of Dr. Poe and 18 years in the custody of Lisa. The bailiff will take you into custody. You're bound over to the Hines County Detention Center until such time as you can be transferred to the custody of Mississippi Department of Correction.
One of the prominent Karens is Alex Jones's lawyer. In this instance, the judge is warning him of potential contempt of court charges.
Well, Twitter photo of the kids lined up just a few months ago. Did you hear that?
Yes.
Did we see that photo earlier? So, Judge. Same video, Your Honor.
Yes, I believe it.
Excuse me. It is
I'll see counsel on the sidebar, please. It is the same video, but here's what I'm going to tell you. I don't know how to say no colloquy, no comments. I don't know. What else do I need to say?
If it's directed to me, I'm not going to sit silently.
Well,
He's looking at me and telling me it's the same video. It's not. I was showed 1E. He's showing 1C. It's a part I didn't show. It's beyond the scope. And he's going to. I'm not going to take an admonishment in the presence of the jury from my adversary. I'm just not going to take it. We're ready.
No, not yet. I'll start with Attorney Maddie. What do I need to do to stop the comments and the call? Just tell me what I need to do. Do I need to hold one of you in contempt? Attorney Pattis? I'm not going to have the comments anymore. I'm not going to have it. I'm not going to have it.
Now, we have the time Alexandria Ocasio had to use a gavel on an ICE member.
Would you like to address, and would you please address any of the...
Yeah, I want to address the last comments made about me being appalling. And first of all, I served my country for 34 years. I saved many lives, and I ran an agency. Let's be frank in what ICE does. ICE last year took a season of opioids off the streets of this country that could every man, woman, and child in the United States twice. They've arrested thousands of predators that preyed on children. They rescued thousands of children who were victims of predators. They arrested hundreds of women who were victims of trafficking. I am proud of the agency in ICE. And what we don't want to talk about is nearly 90% of everybody ICE arrests for immigration violations either have a criminal history or are pending criminal charges when they were found. I mean, they were found in a county jail, which most likely means they weren't a choir boy. So to mismessage what the work the men and women of ICE do is, I find appalling that a member of Congress would throw that out there like that. In my 34 years, I've never seen such hate toward a law enforcement agency in my life that you want to abolish them rather than doing your job and legislate. If they don't like it, legislate. You can't.
Mr. Homan, according to the rules of this committee,
of enacting laws.
Mr. Homan, your time is expired.
Two Karens in the courtroom audience had outbursts following the sentencing of the defendant.
I just got to do what I got to do. All right, Mr. Sato, anything, sir?
No, Your Honor, thank you.
Okay, all right. Here's where the court's kind of, where I think all of you are kind of stuck between. There is the standard for bond, which is the preponderance of the evidence. And then there is, and that proffers are authorized by our state Supreme Court for bond. They are not offered or not authorized unless otherwise agreed to for trial. And that strict burden or strict proof is required for that particular proffer as a result to a issue of proof at trial. So we're stuck in between the two burdens in this case. We also acknowledge the fact that, the defendants are presumed to be innocent.
In another instance, a male Karen attempted to make a sassy comment as he left the court, but the judge promptly shut him down.
At this point in time, I don't find any change in circumstances that would allow me to, or move me from changing my decision as to bond. And if anybody's in the gallery and you can't otherwise control yourself or otherwise you want to make any appropriate comments, then you can leave at this point in time. No harm will come or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.
In a unique occurrence, multiple judges were engaged in arguments, leading to numerous instances of the gavel being slammed to restore order.
Time has expired. We will now proceed to the first round of questions. Point of order. Pursuant, gentleman will state his point of order.
We've been told that counsel for the Democrats was a witness, and that's why he didn't have to comport with the rules of decorum. And now he's sitting up here.
Gentleman will state a point of order.
I've been a judge, and I know that you don't get to be a witness and a judge in the same case. That's my point of order. He should not be up here.
It's not a point of order. Gentleman is not recognized for parliamentary inquiry.
Mr. Chairman, what is it?
Gentleman is not recognized. The gentleman, Mr. Burke, has the time.
We're going to ignore the rules and allow witnesses to ask the questions. Then how many other rules are you just going to disregard?
Gentlemen will suspend. Parliamentary inquiries are not in order at this time.
Well, how about a point of order? This is not appropriate to have a witness be a questioner of somebody that was a witness when he was.
The gentleman will suspend.
It's just wrong. Well, I made a point of order and you won't rule on it.
I have not heard a point of order.
This grandmother Karen has brought her daughter-in-law to court for child support. Right from the start, her behavior indicates that she is nothing but a bully.
Ms. Miller, you brought this case before the court. What is going on?
This is my
future daughter-in-law.
Baby mama.
Okay. Future daughter-in-law.
And Tracy. So Tracy leaves the kids with me and didn't come back to check on the kids, haven't done anything, just dropped them off and took off and expects me to take care of the children with no money. She doesn't drop food off, she didn't leave any clothes, she didn't do anything. Tracy says she works all the time. That's what she tells me.
Okay.
That's where she is. So she hasn't done anything with the kids.
Okay.
And they're small kids. They're 3 and 4. I'm trying to deal with a 3 and 4-year-old while she runs around and does whatever Tracy decides she wants to do.
Okay. Is her name Tracy?
Yes, Tracy. Tracy, I guess is what it is.
It's Tracy, Judge.
Okay.
It's not that hard. It's just Tracy.
Oh, okay.
So special. She's very special.
According to your son, I am.
Okay. Tracy,
just
what's
has bad
your
taste
last
in women.
name?
My name is Tracy Smith, Judge.
Smith, okay.
Yes, and I'm prepared. I've watched your court hearings on Zoom and the
Kiss
other
it
courts.
up. Are you really kiss it up?
Excuse me. There is nothing wrong with watching hearings on Zoom. That's not kissing up.
It just sounds like a kiss up to me.
No.
Well, that would be Tracy. That would be her.
Okay. Mrs. Miller, we're going to be nice and respectful.
I apologize,
It's not
Your
kissing up if she is watching court on Zoom. That's why we live stream, so you can watch it. And a lot of people watch it to get prepared. I see you have your notes there.
Yes,
I see that she has notes there. That's okay.
Yeah, it is okay, but I would watch it if I wasn't watching kids and kid shows, but that's because I got kids, but
Your Honor, I don't know why she's so mean to me.
Oh,
like,
here
I
go
don't
the tears.
understand.
Here go the tears.
Okay,
Here go the tears.
hold on. Miss Smith, I'll get...
It seems like this woman has a lot to say about everything.
You know the things that she do.
She claims she's working, but she claims she has no money. I'm trying to figure out how that works. How do you work but have no money for your children? I mean, I'm confused because I don't understand that.
How long have the children been with you?
6 months.
6 months. And who dropped them off to you?
She did.
Okay.
Tracy did.
I'm assuming the two of you don't get along.
She's not my favorite person. No.
Oh, okay.
No, she's really not.
I mean, well, why is that?
I just
curious.
Because she lies. She's not taking care of her children. She tricked my son into having children with her.
I did not
just
trick
don't
your son
understand.
into my bed. I didn't
don't
trick your son into my bed. He got there voluntarily.
She kind of got a
That's
point
what
there.
you offered.
And very happily, might
That's
I
what
add.
you offered. So he got in the bed.
Okay, so how do you know their relationship?
My son tells me things.
Right.
And
You
then-
only get it, hear me out, you're only getting information from your son. And I'm not saying that your son is not being truthful, but that's just one side of it. It's always another side.
I see stuff.
And it seems like you're very passionate about your grandchildren.
Yes, I am.
So you should at least pretend to get along with their mother. I mean, she did drop the kids off to you, so she must trust you, right?
I don't say anything bad about her.
Wait a
to the
minute, wait a
children.
minute. She did trust you enough to drop the children off to you, right?
Or she had no one else. Well, but-
Okay, but even still, with having no one else, she could have put the kids with somebody that she really didn't know.
Not my grandchildren, she
That's
wasn't.
my point. She trusted you enough to bring them to you.
Good point.
Did you all communicate at all about why the children were being dropped off to you?
My son is in the military.
Okay.
So Tracy, should be taking care of the children.
Okay.
But she got this new career that she has to worry about. So
That's a good thing, right?
If it'll keep you away from your children, no.
Okay. Anything
Sure
else
is.
you
Look
want
like
me
it
to
costs
know?
a little money too, don't it?
And it sounds like that's a conversation you need to have with your son on another day. Is there anything else
There's
you
no
want me
proof
to
that
know?
he paid for that, though.
Is there
There's no
anything
proof.
else you want me to know?
No, Your Honor, that's it.
And he just recently joined the military.
I'm sorry, I should have had some water before I sit down. I apologize.
The situation becomes increasingly absurd with each passing moment. At this stage, the judge is simply disappointed with Karen's attitude.
Girl and stuff. And then he went and got this girl right here because she did things with him that little Keisha wasn't going to do. But that's neither here nor there. I don't want to slander her. But I do want to say that Miss Influencer should be able to pay for her children that live with me. She brings like Rice Krispie treats and cookies and that ain't no food. They need noodles. I don't know how to cook noodles.
I have one question. When she dropped these children off to you, did she say that she was never coming back to pick them up? Or did she say that this was a temporary situation?
She said, I am pursuing a career that requires me to travel a little.
Okay.
So I need you to watch the children while I do that. Well, of course, they're my son's children. Of course, I'm going to watch the children. But no, she did not say that it was going to be this long and she was going to be gone.
Did your son tell you it was temporary?
Well, I don't like to bother him, with some of this stuff.
That wasn't my question. Did your son tell you that this was a temporary situation while they were trying to sort things out with military and a
he
job?
said why she started her little career.
Okay, so
that you need to watch. I was gonna have the kids.
So you agreed, and I believe there is.
But 6 months.
Do y'all have anything you want me to look at? Because I see that you have documents over here. I see that you have. Looks like you just have notes.
No, I just have my notes, Your Honor.
I have the email that my husband, my almost husband, sent to his mom.
Could you stop saying that? And you have his email address, don't you? Don't you check his email? So you probably sent that email.
But how do you know?
Thank you.
Because that's the kind of person she is.
Come on, Mrs. Miller.
The email
Thank
states,
you.
Finally, the judge dismisses the case, and the Karen grandmother does not get what she wants.
She's never here. She's traveling with that little new job.
Call her, and you all sit down and have a conversation. Get to know each other. This is not the place to do it. This is where bitterness, bitter feelings, all of those things come into place. This is not the court. This is not the court. This is not the place to be doing these types of things. All right? I'm going to deny your request, and I'm going to dismiss this case because you do not have a reason to ask for child support. It's very clear from this email that you knew what the situation was and you agreed to help them. And you're getting financial support from it. It's just not what you're looking for, but that was the agreement to continue paying the bills and everything like that.
Here in Lauderdale, Florida, Tyra Vanzant is facing a long list of charges, including grand theft and resisting arrest. However, as the judge begins to sentence her, she's already pleading her case to a higher court.
Thank you, Jesus.
in Jesus' name, say asking a child reading, please let me be released from this jail board. Thank you, Jesus.
Unfortunately for Van Zandt, the ultimate judge isn't presiding over this hearing. Instead, it's Judge Hurley who seems caught off guard by the defendant's prayer.
Jail board. Thank you, Jesus.
Before Judge Hurley delves into Van Zandt's charges, questions about her professional life take center stage.
Are you employed when you're not in jail?
Yes, sir.
What type of work is it? Oh.
I work at Pure Platinum.
After hearing this, the tone of the hearing begins to sour.
They had to tase the defendant to bring her down. She wouldn't stop.
A closer look at Van Zandt's recent criminal history also reveals that this isn't her first time facing very serious charges.
You've been arrested 8 times in the matter of a couple of years. I don't know, it's like every time you go out your front door, you know, you're getting arrested. So she gets arrested, you said in June? She got arrested in June for obstruction, for and now she has to get tasered in and she wants me to let her out and have a second chance. Huh, interesting.
Please, I'm asking you for a second chance, sir.
Well,
please, so I can get my life together.
I wonder what you told the judge after the first, the second, the third arrest, the fourth arrest, the fifth.
Please, I'm in a Christian unit program here, sir, and I've come to found God, and I'm really changing my life, and I just want a chance to be able to go to a rehab, sir.
Right.
Please have mercy on me, Judge.
After a short pause, the judge delivers his ruling.
Ma'am, I'm going to let you stay in right now. I think that's the safest place for you. Thank you.
Oh, my God.
Tyra was then sentenced to 180 days in jail, as well as 3 years of probation. This woman is displaying very petty behavior in court. The judge has to intervene and tell her to tone it down.
He said that he sees the children now 4 times a week, and you're saying that's not true, except for like a FaceTime video or something like that.
He sees the kids on an inconsistent basis.
That's a lie, Your Honor.
Okay. So when you say inconsistent, right now, do you all operate under a standard order where it's like first, third, and fifth?
He has every weekend, and I have during the week.
Okay, so every weekend he has.
Right.
Okay. During that every weekend, it's inconsistent, is what you're saying?
I mean, it's just all over the place. He just comes and goes and sees the kids whenever is convenient to him, or maybe his girlfriend like turns him down for a date or whatever.
Okay, so that was petty.
What girlfriend you talking about?
We didn't have to go there. We didn't have to go there. So is that what the issue is? Like, you're still mad at him about that story that he told?
Well, okay, so he put in a bid for an upgrade, or the upgrade put in a bid for him or whatever, and now I have to explain to our son why our family fell apart.
Oh, so it's some hurt feelings there.
The woman's reasoning seemed valid initially. However, she made a significant mistake by not reading her court order.
Technically is what you said, but is that what your court order says?
Well, the court order says Dallas and contiguous counties, and he moved like a mile on the other side of the Ellis County line.
Okay, and I do have a copy of your court order here, and it doesn't mention that it's automatically lifted.
Oh, okay. Well, I was just thinking it was the one that.
O is right.
Thank you, Your Honor.
O is right. What?
I'm sorry.
O is right, because you can't just leave. You can't just do that. You actually have to ask permission to modify this order like he did.
Well, can I modify the order to move to Florida?
Did you file anything for today?
I mean,
It's a yes or no.
No.
Okay. So you're moving without asking the court, can you move? And Dad is still living here.
Well, I guess I just didn't understand the way the order was written, because I had heard that if he moved outside of where it said, then I could move out.
Who did you hear that from? Did you Google? You did one of those Google searches? One of the Google lawyers told you that?
Yeah, I guess.
Oh, okay. Because they told you wrong, and that's the problem with Googling everything. You should have actually consulted with an attorney who would have interpreted this order properly to you. You can't just move. So let me tell you what we're going to do, because I think this is the fair thing to do. Regardless to whether you say his visits are inconsistent, he say they're consistent, the reality of it is when you move to Florida, he can no longer have access to those kids. So even if he were coming this day, and did every weekend, he won't be able to do that anymore now that you are going to move to Florida. So what I'm not going to touch is your custody arrangement. Not going to touch that at all. This is a child support court. That has nothing to do with us, okay? So I'm not going to touch it at all. You are free to move to Florida. However, he's coming off child support. So then he can use the money, the $880 or so that he would give you for child support. He can use that to travel to actually see the kids.
But what if he doesn't, Your Honor?
Well, if he doesn't, then after some time of him not doing it consistently, and when I say consistently and consecutively, it needs to at least be about 6 months or something like that, right? Then you can come back and let me know, Judge, he's not exercising regularly. I need some support for these 2 kids, right? But absent anything like that, I believe that's in the best interest of the children. And quite frankly, that's fair. You're moving without permission, right? Which is a violation of your court order. So it's only fair that he stops paying child support. So beyond a reduction, he's coming off child support today.
This woman arrives at court, convinced she's entitled to child support. However, the court's response will shock her.
No, that's not how any of that works. That was really creative though, but that's not how any of that works. So let me go ahead and tell you what the results say.
All right. Let's get it over with.
All right.
Drum roll.
All right. It looks like baby McKinney, because we can't say a child's name.
Right.
There is no probability he can be the father.
What did they say? What? You hear that? What'd you say, Your Honor?
You laughed at that.
Remember no, I didn't hear.
Oh, let me say it a little
I'm the
louder.
only white person she's been with. Remember,
there is no probability that he is the father.
Okay, so first of all, no disrespect to you, but the letter looks a little sketchy.
Okay.
It wasn't in a legal size envelope.
That's why it's sketchy.
So, and I don't trust him because his uncle is an attorney, okay? And his uncle can do all types of stuff. You know what I'm saying?
Okay.
So I don't even trust that.
Wait a minute, I believe at the beginning, I asked you all how the test went. And you said, wait a minute, hold on. You said everything went good, right?
And it did.
And it did, and it was fair that day, right?
Yes.
They swabbed her mouth correctly.
The person appeared to be wearing PPE and the person appeared to work, you know, for that service. And the test itself went well, but behind the scenes, Your Honor.
And it appears that these results are directly from the testing place. And he's not the father.
He is the father. Let me tell you why. Let me tell you why, Your Honor.
Let me tell you not. No, he's not.
He's the father.
He's not. So you're going to you're going to argue with DNA testing.
Your Honor, he is the father. 72 hours. He has a tattoo on his private parts. He was the only one there. I know
father. He is not the father.
Show
How
me a
many
tattoo.
times do I have to say that? No, I don't want to see a tattoo. All I want to see was these numbers to see what the probability was going to look like of him being the father.
Woody Smith was in court for murder, with a bunch of tattoos on the back of his head, which we all know what that implies. On the day of his sentencing, Woody said this to the judge before the hearing proceeded.
Okay, I would just like to say this. I was told before I came here that my haircut might...
Please don't talk about your haircut, sir. Just
okay, I was told it would be disrespectful, but it's not disrespectful because I love my wife very much.
This is not about
okay.
the jail or anybody else. This is about
okay.
you. And
okay.
I need to know what you want to tell me about this case.
Okay. Well, I want to tell you about this case. I understand what the jury have chosen, and I don't go against that because that's their decision, but I do not believe, and I know the Lord knows the true outcome of the things that happened. So I trust in the Lord, and just like when I decided to take this to trial, I trusted in the Lord. I still trust in the Lord. There's a reason that He's sending me to prison, and so be it. And I just want the court and everybody to know that I love my wife very much and I would never hurt her. That's all I have to say.
Now, we have a man named Lawrence Sullivan, famously known for his face tattoos that resemble the Joker. Sullivan has been in and out of jail countless times. This time, it was for carrying a firearm without a license.
The next one is, this is Lawrence Sullivan.
Present, Your Honor.
Pardon me? Oh, this is Mr. Sullivan? All right, good morning, Mr. Sullivan. You're charged with 1 count of carrying concealed. I've appointed the Public Defender's Office to represent you. I'm going to be taking a look at your arrest affidavit to see if there's probable cause and address your bond status, sir.
Your Honor, I'm being told that Mr. Sullivan has declined the services of the public
Is
defender.
declining services. Is that correct, sir?
She's talking to you. She's asking you.
You don't want the Public Defender's Office to represent you?
I mean, you can represent me, but I'm trying to get bonded out, my honor.
Well, they're there to help you, sir. You don't have a lawyer.
All right.
I mean, okay, so...
I didn't even feel like signing the paperwork. I'm really not in the mood for that.
Okay, well,
I'll take
you're in custody, okay? You're charged with carrying concealed, which if convicted has some serious consequences.
Sullivan didn't get life in prison, but he was held on a $5,000 bail. In this next clip, the judge puts the defense attorney in his place for overstepping.
Mr. Shellhorn. Judge, I think there was a question there suggesting that the attack, the dog bite, and I think there was something else was going on before.
I don't even know what I don't even know what the factual basis is for that.
Judge, I can ask a witness.
No, you can't. No, you can't. Not without a factual basis. You just can't ask for speculation. That's what you're asking for.
I'm asking you a question whether or not.
There's no evidence that it happened before. None. Not a scintilla of evidence on the record so far that supports that question.
If a witness says that something happened, I can't ask them if...
You've asked them 500 questions about what happened, about her recollection of it, which is fine. Now you're asking, well, are you sure it didn't happen before? You have no basis to ask that.
Her recollection is horrible.
No, it's not.
She's changed her story over and over.
It doesn't matter. It doesn't, Mr. Belinkus, it does not allow you to suggest to this jury to engage in speculation, which is what you're doing. Your client doesn't remember the incident, according to the expert reports. So that's not a factual basis for you.
This next defense attorney really knew how to stand his ground in a case like this, which isn't comforting.
Please, the court, Your Honor, we have a motion to compel, we filed, we heard on it, and then if they want to respond, Your Honor obviously will hear that. We filed this motion weeks after they failed to comply with Rule 5 and Brady, and just ignore that. I think that's a disservice to this court and the criminal justice system.
The only reason why the...
Your Honor, I'm not judged. If I could be heard without being interrupted and hijacked by the state as they continue to try to hide the ball on this case, I'm sorry if I appear upset, but I can tell you that every time we turn around, they're trying to hide something. And if we could just have 15 minutes to address the court and call the witness, we could get to it.
Your Honor, to set the table appropriately, I think the protective order, which is what started this whole issue, is the way to set the table. And I would point out that Mr. Harpoon stood up and interrupted me as I was trying to set that table.
Your Honor, that table has never been set. They won't comply with Rule 5. They could have raised this protective order issue 7 weeks ago and didn't do it. So
that's because the defense agrees with that until after
Again, if I would be allowed to finish without being interrupted, I know he's had a mistake like grand jury. I know he's a very important guy. But my client has a right to a fair trial, and a fair trial means a motion to compel to find out what it is we're trying to compel and not have the Attorney General continue to try to hide behind whatever this is.
We have this Karen who was caught red-handed doing this.
Kraft allegedly spray painted racial slurs on her neighbor's driveway in Lake Forest in June, not once, but 3 times. One incident captured on the Pineda family's security cameras. She was charged with harassment and criminal mischief. The court issued a no-contact order on July 16th. But on July 27th, the Pinedas believe she was caught on their cameras again.
She was coming from her residence into our yard and pouring a chemical in our yard, and the next day is when we noticed it. It looks like it's in the shape of.
If you thought she couldn't do anything worse, it gets way worse.
Pinedas say they've also seen shards of glass thrown into their yard.
I just saw something get thrown over. Hold on.
Capturing this moment on their cell phones.
There's glass. Again.
They also claim they found hot dogs near their backyard playground with glass in them. This family says they don't feel safe knowing Kraft is only 2 doors down.
I feel like maybe she's just trying to push us out of the house at this point.
I want to make sure you understand. You may have posted bond, but the court can put you back in a heartbeat.
A stern warning Thursday afternoon in court as Suzanne Kraft stood in front of a judge accused of violating her no-contact order filed by the Pineda family, who watched and listened from the hallway.
I'm not saying that you've had contact. I just know there's an allegation. And what I'm telling you is, if they can prove it, then you could very well end up back in jail.
Another defense attorney who is terrifying is Mark O'Mara. He always puts up an interesting argument.
No other reasonable hypothesis that could come from that undisputed evidence other than my client was attacked by Trayvon Martin. That violent act in and of itself, I would suggest to you, is sufficient for immediate response with deadly force. But he didn't. What we have is 40 seconds of somebody screaming. Of course, you know, my client, through his statement, said it was him screaming. 40 seconds, and receiving additional injuries consistent with, and even the state's own experts said it was consistent with, my client's head being bashed against concrete. To date, and the state's case is now done, to date, they have not presented any direct evidence, and I would suggest not even circumstantial evidence, that my client followed him after being told not to by the dispatch. They have no direct evidence, no circumstantial evidence that my client ever moved from the T intersection down the dog path until he was drugged or forced there by Trayvon Martin. There's not a scintilla of evidence.
Now we have Adrian Bronner. He appeared in court after a woman accused him of assault. However, the judge brought up a completely different topic while he was there.
I don't know what you guys want to do. I'm answering the questions. When I answer questions, that's all I did have on me. I don't have them. I got rich friends. I do. I got rich friends. I got wealthy friends that take care of me.
Where's all the money coming from that you're flashing around on Instagram? Whose money is that?
So you're on it.
I asked you.
It's getting sent to me. I don't
By
have
who? Who's sending you money?
my friends.
They're sending you. Why would they send you money?
Because I asked if I need. Listen. I got a big heart. I got a big heart. I'll show you. I got a big heart. And when I did have money and everybody asked me for money, I gave it to them. And now that they see me that I need help, if I ask,
So tell us who's sending you money.
my friends. I can ask Devontae Davis, Al Heyman. I can ask Steven Espinosa.
Bronner definitely thought it out, but he still doesn't give the judge a straight answer, resulting in this happening.
Take you that long to answer these questions.
No. What I'm saying is this. After the fight, I can just pay them.
That's irrelevant to me. You know what? I'm not interested. I'm not here to listen to people say I'm going to give you the money here and there and disregard every court order in the interim. This is a problem, Mr. Bronner, because you have ignored basically every order I have given you. And now there is a punishment. I've given you extensions. I've given you time. I trust you're going to get this done well before your January fight.
ended up receiving 120 days in jail for contempt of court for not complying with the civil case he was there for. It didn't stop there, though. In 2019, Broner was placed on probation for 2 years after pleading guilty to 2 counts of misdemeanor. Casey Goru is one of the scariest attorneys, and this video proves it.
Twin Peaks, Your Honor, that contains information that is exculpatory and that seriously undermines the state's theory of prosecution.
First of all, I'm going to object.
May I finish?
No, I'm going to object to the statement right there. These interviews happened after the Twin Peaks. Any assertion of otherwise would just be a flat lie.
Well, may I finish? I'm sorry. Make the record, Judge.
You may make a record.
Thank you. There are 2 interviews with this particular individual, one prior to Twin Peaks and one after Twin Peaks.
Judge, I'm going to object. That's a misstatement of the facts.
We can play them in open court, but the point, Your Honor, is that this district attorney's office, including Mr. Jarrett and Ms. Dylann and Mr. Reyna, are sitting in a room where witnesses 2 years ago, 2.5 years ago, are making exculpatory statements. And they say that they don't have possession of the recording, but that they had actual knowledge of the contents of the recording. And I'm happy to recite page and verse, Your Honor, of the witnesses and the statements that they've made that frankly should have prevented the state from sponsoring the testimony of all 3 of their quote-unquote experts and would have materially changed my cross-examination of every witness that has testified, save for the first young woman who was a waitress at Twin Peaks. No, she was a cook at Twin Peaks. I mean, I don't know how this isn't Brady, and it is certainly willful. And that fine line of saying, well, we didn't have the recording, you were there. They were physically present in the room when those statements were made.
Next, we have Steve St. Felix. He was in court for making an online death threat in which he threatened to get rid of all Republicans. He didn't help his case with this outburst.
Get the cameras out of here, man. I know Marco Rubio, Nelson Diaz, Manny Diaz Jr., Carlos Jimenez, Rubino. That better go get Cuban sandwich, bro. Get out of here, man. Get him out of here, man. Gotta bury my family, bro. It's torturing my son. Mr. Story attorney, man. That's torturing my son, man. I got 2 sons, man. That's torturing my son, man. Get him out of here, man. All right, cameraman. All right. Uncle Rubio, Miami, right? Right, that's right, man.
After his courtroom outburst, Felix remained in jail on a $500,000 bond. He then entered a diversion program for his mental health. We have a judge who lost his cool with the defendant and her sloppy attorney.
All right. Ms. Morales.
Judge, can I just have one moment, please?
Sure.
A few minutes. She's on her way.
All right, we'll pass it. The Public Defender's Office is about a 2-minute walk away. Your colleague is not here. It's 20 minutes later. I'm going to call Ms. Morales' case back. Yaneli Morales. All right. Good morning, Ms. Morales. You're charged with a burglary with assault or battery. I'm going to find probable cause for that offense, ma'am.
The judge then confronts the attorney.
Your appellate attorney asked to be here 20 minutes ago, and she is not here.
Judge, but
it
now...
shows a blatant disrespect to this court.
Judge...
Mr. Thompson?
No.
It's about a 2-minute walk from the Public Defender's Office. Where is your colleague?
Judge, may I have just 1 minute?
Nope.
I would like to have a supervisor present.
Your office is here. You are here. I've given your office the courtesy to come down here. Your colleague has apparently hung you out to dry. I'm not really sure why, but you're now making conflicting arguments.
I'm not saying the court...
I'm asking you to explain this inconsistency.
Judge, what I'm saying to the court
is on that question.
To be fair, the attorney did lie about his partner being on her way. However, what the judge did next was a bit harsh.
What I'm saying to the...
All right, we're all done then. All right. State anything else? Ma'am, you're going to be held without bond at this time. Good luck.
Now, let's talk about the time a judge threatened a girl. The mother was a bit out of her mind, but the judge went too far.
He has not paid child support. It was November, December, and January that I did not get child support or alimony. Also, none of the medical or dental has been reimbursed, ever. Not 1 penny of that.
Child support, if there are arrearages, and medical, if there are arrearages, you need to file a schedule of arrearages and a motion, and I will hear it at the appropriate time.
Medical and dental was filed. I remember, I believe it was 5 court dates ago, And I have submitted receipts, proper receipts.
Keep your comments to yourself.
It's more than a week away from now.
I'm not taking argument right now. I have listened to this case ad infinitum. I am entering orders. I expect them to be followed. I'm trying to accommodate both parties. We're not going to do this on a whim and say within 2 days he's going to have dinner with her. Mom's going to tell her it's going to happen, and we're going to get prepared for it. Okay? What time?
Whatever's good for him. 5, 6.
What time? 6 p.m.
Is she going to have to ride in a car with him?
Yes.
Wow. You really care about my child, don't you?
I want you to keep your mouth shut and sit down. I care about your child very much. You do not. Sit down and do not talk.
We need to have a trial.
There's no need for a trial.
Oh, there he is.
If there is contempt, and if there is withholding of the child, we will have a trial. Do you understand me clearly? You will lose custody.
You don't understand. I love her. And I'm gonna miss her so much. Please don't do this to me.
I've made a decision for your best interest.
How do you know my best interest?
I'm a grown-up and you're a child.
Please. I don't want to be with him.
If you have any difficulties, we'll go to Child Haven. It's not fun in Child Haven. In fact, they put you in a holding cell, just like it would be jail.
This next judge doesn't even give the victim's attorney a chance to introduce herself. A total coward.
04-001, State of Arizona versus Christopher Robert Lesniak. All right, does the state want to make a record?
No, Your Honor, no offer has officially been made yet.
Ma'am, please be seated. Please be seated.
I was going to make an announcement.
Please be seated. And you'll make an announcement only when the court allows you to do that. Thank you. And fail to appear for your next court date, which is August 31st. A warrant could issue for your arrest, and your trial could proceed in your absence. You understand that?
Yes, ma'am.
All right, good luck, sir.
Judge, I wish to be heard.
Sir, ma'am, sit down, please.
I wish...
Ma'am, sit down. That's the last warning, otherwise get out of the courtroom. Leave the courtroom, or I will have you removed from the courtroom. I will have you removed. I will have you removed. Get out of the courtroom right now. Out of the courtroom right now. Get a deputy in here right now, please.
Judge, can I make a record? I'm sorry, but I've spoken with Sheila Madden. She represents the victim in connection with this case. I've worked with her, so she represents the victim. She was very professional in contacting me. She's a former judge. I hold her in high esteem just as I do you. So I don't want to be cut in the middle here, but...
I'm not taking any comments with regards to the victim in this case. That is for a later hearing.
Now, for the time, a senator brought a judge to tears by praising all of her achievements.
There and you went to private practice, and you know what you found? This is what you told me. That you had those tough choices that working moms have to make, the demands of a private law firm, raising your kids. It just didn't add up. You went before this Senate 3 times in a bipartisan manner. God bless America. We don't do that much stuff bipartisan around here. You went to become a public defender because you wanted to understand all aspects of the law. Who does that? We live in a society that's very materialistic sometimes, very, very consumeristic. You went to, do people become public defenders for the money? No. Your family and you speak to service, service, service. And I'm telling you right now, I'm not letting anybody in the Senate steal my joy. I told you this at the beginning. I'm embarrassed. It happened earlier today. I just look at you and I start getting full of emotion. I'm jogging this morning, and I'm at the end of the block I live on. And I get terrified because I put my music on loud when I'm jogging, trying to block out the noise of the heart attack I'm having. And this woman comes up on me, practically tackles me, an African-American woman. And the look on her eyes, she just wanted to touch me, because I'm sitting so close to you, and tell me what it meant to her to watch you sitting where you're sitting. And you did not get there because of some left-wing agenda. You didn't get here because of some dark money groups. You got here how every black woman in America who's gotten anywhere has done, by being like Ginger Rogers said, I did everything Fred Astaire did, but backwards in heels.
Now for the time a victim addressed the defendant in court. She gave a heartwarming explanation of forgiveness and why she was forgiving her. The court was excused soon after.
I'm a strong person. I'll keep fighting. But what happened to me should never happen in the state of Minnesota. It shouldn't happen to anybody just because you're different. And I hope that if I could ask you if I can talk to the defendant, would that be okay?
Sure.
Jody, what you did to me that day wasn't good. You should never do anything like that to anybody. But I just wanted to tell you in front of everybody today that I do forgive you. My religion teaches me to forgive so I can move on with my life. If I hold a grudge and I hold the hate you hold towards me against you, it's not going to serve me well. So in front of everybody here, I do forgive you, and I hope that you choose love over hate. I really do, because it makes your life easier. Having hate just eats at you. It's not good. I hope you find what you're looking for, and I hope at the end of this journey, I know you've had just as long as a year that I have had, and my intention for you is not bad. I don't have any ill feelings towards you. I just want you to, at the end of all this, to understand that we're all the same. It doesn't matter what's on my head. It doesn't matter the color of my skin. We're all the same human beings. We're fighting for the same rights. I'm an American citizen, and I fight for this country. Today, I would fight for it as much as you would.
Now for the man named Bradley Jean. He acted as if he did not care he was in court. This is how he spoke to the judge.
Being filed under coverage of the news this afternoon, as it always is. Also, Your Honor, I would...
Your objections noted for the record and overruled. I have nothing else to take up in your cases today, Mr. Yon, so I'm going to remand you to custody sheriff.
Your Honor, I am my own attorney. I have some issues to take up with the court.
If you file a written motion, notify the state of those issues, and then we can schedule those for a hearing.
It seems like things don't get filed, Your Honor. The clerk just is not filing. That's one of my reasons. Maybe it often do.
Mr. Yon, you're remanded to custody of the sheriff.
The clerk will start filing my stuff. And the clerk will never file my stuff. That's why I'm sitting here trying to argue. Piece of shit.
Let's go.
He's done. I'm tired of this shit. Y'all just railroad the shit out of me.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.